Good morning, dear ladies and gentlemen. We're kicking on in a few minutes, so please take your seats. So before we start, just a few words of appreciation to our sponsors, ERG, Chevron, Visa, Huawei, China Construction Banks for their financial support and making this event happen. As the name of the session suggests, today we're gathering to discuss the issues of legal and tax aspects of operation business in the AIFC as an AIFC registered company. So before we I'd just like to make a few words of introduction. We're all part of a company called AIFC Business Connect, which is a AIFC body which helps company register and operate their business in the AIFC. Let me introduce the panel of our today's speakers. Tamerlan Ildibayev, Aisha Manapova, and Arsen Amanbayev. They're all part of a structural division of structure and business solutions of AIFC Business Connect. So today's session's objective is, as the name suggests, is pretty much clear. It's to understand what are the critical and typical, let's say, like aspects of setting up a company in the AIFC, conducting a business in the AIFC, and a sale of or transfer of shares of company to a third party. That is, we want to cover like all the major aspects of a life cycle company set up in the AIFC. So without further ado, guys, I'd like to pass it forward to you, like to, describe what are the key, let's say, like legal forms one can incorporate a company in the AIFC, and also, I guess, like a particular point of interest would be to understand the concept of recognized company, because like that's one of the most frequently asked questions that we receive. So if you could dwell on that. Thank you.
Thank you very much. So as you know, whenever a business comes to the AIFC, the first question that is asked by the legal advisors of that business or by management of that business is, of course, which legal form to choose in order to incorporate its business here in our center. We do have a number of legal forms available as part of our law. They range from companies limited by shares, we have partnerships, foundations, which include general, limited liability ones. However, based on the data that we have so far, we conclude that the most popular legal form that our participants choose is that of a company limited by shares. And that is why, since we have quite a limited time today during this session, we will focus only on companies. And as part of the first section of our session, which is entry to the jurisdiction, we wanted to focus on one of the most frequently asked questions, and that is, what is a recognized company? A recognized company is this sort of enigmatic concept also prescribed by the legislation that regulates companies as a whole, and that consists of the companies regulations, or comregs as they are informally known, and companies rules. And the question that is asked by lawyers, especially Kazakh lawyers, is whether or not a recognized company is essentially the same concept as that of a branch as prescribed by the Civil Code of Kazakhstan. In accordance with the Civil Code of Kazakhstan, a branch is a structural division of its parent company. It is established on the basis of internal corporate documents. It gets property from its parent company, and its directors and officers act on the basis of the relevant corporate resolutions of the parent company and powers of attorney issued by the parent company as well. If you look at the AIFC concept of a recognized company, which is regulated by Part 12, a separate part of the company's regulations, a specific part, you will see that even though in name the concepts are quite different, in substance they are pretty much the same. So the requirements for a recognized company, as stated by the legislation, are the following. You have to have one person authorized to accept service on behalf of the recognized company, you have to have a registered office address in the AIFC, and you have to comply with certain filing requirements, e.g., for example, you have to submit your annual return and financial accounts that were prepared in the mother jurisdiction. So as you see, the concepts are, I would contend, pretty much the same.
Yeah, Aisha, I just wanted to add that maybe our audience is much more the concept of TO, the legal form that usually used in the general jurisdiction of Kazakhstan, is conceptually more understandable for our audience. And I just want to mention that, as far as I remember, in the legislation, in general legislation of Kazakhstan, it actually states that branch is not a separate legal entity. I mean, it's kind of a direct, clear provision. Is it the same in the AIFC Act, or it's more like not on the surface?
Yes, so you are completely correct. In the Civil Code of Kazakhstan, you get a very nice, very easy to understand provision that expressly says that a branch is not a legal entity and it's a structural division of its parent company. In the AIFC Act, you will not find a similar provision. However, the situation and the position is actually the same. However, it requires analysis of a number of different provisions of the Comregs. And the first one of those is the provision in the very beginning of the Act, which deals with a separate legal personality of companies. And if you look closely, the provision only relates to companies, capital C. So if you go to the definitions section of the company's regulations and you look up the definition for a company, capital C, you will see that it only includes private and public companies. It does not include a recognized company. A recognized company is in turn defined as foreign company established in accordance with the Comregs in the AIFC. So analyzing those provisions cumulatively, let's say, you come to the same conclusion, that it does not have a separate legal personality, the recognized company.
So it's like more from the definition that actually a company from capital C, it does not include directly a recognized company.
Yes.
Okay, thank you.
I think it is important to mention that our recognized company may conduct almost any type of businesses in the AIFC. We can separate them into the financial and non-financial. Non-financial business can be any type of business you want to expand into the AIFC. And financial business, in instance, if your mother company possesses some financial license similar to ours, you can go through the recognition process and establish your presence here in the AIFC. Let's say you have a fund management company in Kazakhstan or in Russia, and you apply to the AIFC to conduct a similar business here. For instance, we have a number of, if I'm not mistaken, Kazakhstan-based and international fund management company and banks in the AIFC represented by recognized companies. Big advantage of such expansion is, of course, expansion to CIS region, as you will have additional tax exemptions, and the biggest advantage is that you don't need to provide minimum base capital requirements. That's the exemption from the prudential requirements.
Thank you, Arsen. I think that another thing worth mentioning today is that even though this discussion is largely academic for legal purposes, there are certain significant practical matters that we need to consider from the point of tax.
Thanks, Aisha. Yeah, I just wanted to mention that from tax perspective, there is a sort of a concept, I would call it the concept of taxation of a permanent establishment. And before diving deep into that, I just want to mention that AIFC tax legislation is based, first of all, on the tax code. And in addition to the tax code provisions, you should kind of use or be guided by the Article 6 of the constitutional law on the AIFC. And it should be noted that the constitutional law does not consider these principles of how the taxpayers should pay taxes, how they should calculate it, when they should report it, and all these matters are covered in the tax code. And from the perspective of a taxpayer and, of course, the tax authority, whenever they meet that recognized company, actually what happens, they look at the definition in the tax code and unfortunately cannot find the direct term of a recognized company. And what also should be mentioned is that it is in Article 1 of the tax code, which actually states all the definitions. This is a big list. And in the list, there is a sort of a general definition called structural division, which by definition includes a branch or a recognized or representative office. And there is a point that there is no direct link or like any reference to any other applicable legislation, like where you can find whether the branch actually includes a recognized company. And it may kind of it may not be helpful just to go to the Article 1, and what should be mentioned here is that there is a general concept where whenever you cannot find a definition of the tax code, you actually should go to any other legislation, the civil law or any other legislation in Kazakhstan, and here is this link with acts of the AIFC defining what is a recognized company. And okay, with that technical matters, just by like jumping to the point, is what, in my opinion, a recognized company by substance from legal form actually is a branch. And in case whenever you would like, whenever you in future meet the tax authorities or just would like to understand how the tax consequences will work for your recognized company, you should just consider it will be the same as for a branch. And what also a key point that should be mentioned here is for Kazakhstan legal entities, whenever they create a branch or recognized company, in case of AIFC here, there is no much difference from taxation perspective. But for non-residents, it should be noted that in case they create a recognized company and actually get a status of a permanent establishment, this P, permanent establishment, defines that such company will be liable to pay 20% corporate income tax, and in addition to that, instantly pay 15% branch profit tax, which actually applies to a net income after CAT. It is a sort of mechanism like whenever you create a legal entity and pays dividends instantly once you kind of have a final result at the end of the year. And it may be reduced to like 5 to 10% depending on the double tax treaty, but what should be from practical perspective noted that the international taxation currently is toughening, and what the requirements to apply the double tax treaty become higher. And you need to consider that from the 1st January 2021, the MLI, so-called multilateral instrument, the initiative of OECD was, it is actually a multilateral agreement, I would call. It was signed, ratified, and started working from 1st January 2021. And it also creates additional requirements for any taxpayer whenever they want to use double tax treaty provisions, with, of course, certain requirements, limitations that I believe are details. But that's pretty much it.
Thank you, guys. I think let me just summarize a few points from this discussion. So, as far as I understand, there are like a variety of legal forms available for incorporation company in the AIFC, but like one of the most prevalent one is the LTD, private company limited by shares. In terms of recognized company, this concept is, let's say, similar or analogous to a concept of a branch, both from legal and tax perspective. And the recognized company can undertake both financial and non-financial activities. And like for financial companies, they are already regulated by a financial regulator outside of Kazakhstan. Recognition process is the most logical way to proceed, I guess, like given the less time it takes to get licensed, and like let's say like less stringent requirements that are imposed on a recognized company. If we move on, like I've set up a company in the AIFC, registered company AIFC. Now I want to finance that company. So what are the critical issues that I need to be aware of when financing company, either through equity or debt. Can you like shed some light on that?
Yes, so indeed, the most popular types of financing that we see being used by participants in our center are equity and debt. With equity, there are a number of legal technicalities that we wanted to highlight as part of our session that we get asked about in practice. And the first one actually relates to incorporators of a company becoming shareholders thereof upon incorporation. There is an express provision to that effect in the Comregs, and why it's important and why we get asked questions about that is because because in Kazakhstan, if you look under the joint stock companies legislation, there is a two-step process to actually becoming a shareholder in a JSC. So first you have to incorporate your JSC, and then you have to register your issue, the share issue and the issuance of those shares to the incorporators of the JSC. And only when you do that in the relevant authority that is competent in those matters, you actually become shareholders. With LTDs in the Comregs, the position is similar to the so-called TOR form and the position that we have in the UK under the Companies Act 2006. So you become a shareholder of the company upon incorporation. So that's incorporation. After incorporation, usually what we see in terms of equity finance is that more shares are being issued by the company to be purchased either by existing shareholders or by attracting new investors. And that, of course, requires us to go through the process of allotment of shares. And in that respect, we wanted to highlight a very interesting and welcome amendment that was introduced by AIFC to the Comregs, and which has been in effect from the 1st of January this year, and that is that the board of directors is now allowed to allot and issue shares without necessarily getting approval from shareholders. Previously, the position was that you did need to go and get a resolution of shareholders before the directors could allot and issue shares. Yes.
But that provision, is it mandatory, or like I can insert it into the AOA and just consider doing so my business, or whenever I want, like a shareholder, I want to keep my, to keep this right, and I can kind of protect my rights in the company. Can I do that?
Yes, actually the general approach that you see throughout the company's regulation in the AIFC is that there are not many the so-called imperative norms. So you can obviously provide a more stringent approach in your articles of association, which will of course prevail over the lower legislative standard.
Okay, thank you.
Another thing in relation to allotment, which is of interest, especially to Kazakh lawyers, would be the preemption rights of existing shareholders. In accordance with the AIFC law, if you are a private company, you may actually disapply or significantly vary the preemption rights of existing shareholders in your constitutional documents. That is not the position under the TOR, where the norm is imperative and you have to comply with that. And that, of course, may make your life much easier as a company and make your corporate secretary, your corporate lawyer's life much easier, because there is a procedure which you can basically get rid of at the get-go. Okay. Yeah.
Are there any other mechanism if, for instance, investor does not want to use cash for pay up for share capital?
Yeah, we actually get a lot of requests regarding non-cash considerations. Yeah. Can we do it?
Yes, we do get a lot of requests about whether or not you can pay for shares in a company by contributing property and not cash. And the Comregs is quite extensive in regulating that procedure. So you get two different sections dealing with the so-called non-cash or in-kind consideration for both private companies and public companies. And another flexibility that our corporate regime offers is that if you're a private company, you do not need to engage an independent valuer to value the property that you accept in exchange for issuing the shares to the relevant shareholder.
Just to mention it, and I believe as our audience might be interested. So I kind of may invest a pen and just call it a 1 million worth investment in a company and get shares worth 1 million. There is no like separate requirement to evaluate it. Does it work only for private companies or like for public also?
Yes, it works for private companies only. As you know, directors in limited companies, they have a number of duties that are expressly and in a lot of detail prescribed by the legislation. That includes the duty to avoid conflicts of interest and other fiduciary duties. And when you owe someone a fiduciary duty, you owe them the duty that sort of ensures that you have to exercise utmost trust and confidence when you are doing that. So if, let's say, in your example, directors do issue, let's say, $1 million worth of shares to a shareholder who gave them a pen in exchange, then if later on there is a court procedure, there is a court claim, you're in for a number of very significant, very serious consequences, ranging from fines to being disqualified to act as a director for a long time.
So this is a flexibility with more responsibilities.
Exactly.
For beauty.
Yes.
Okay.
With public companies, you mentioned public companies, the position is more stringent, understandably. You do have to get an independent valuer to value your property. That must be done not earlier than 6 months prior to you actually allotting shares in exchange for that property. And importantly, the independent valuer must be licensed as an auditor in the AIFC. So you cannot get, let's say, an auditor from Kazakh legislation. You have to get someone who has a license, an ASP license here in the AIFC. And thankfully, we have a lot of those now. Yeah.
Thank you, guys. So can we now switch on to discussing the debt financing? So, like, what are the most important issues one needs to be aware of, like, when issuing a debt? So, like, including convertible debt, which is becoming increasingly popular, especially for the venture capital financing.
The Comregs do not have any restrictions that would prohibit a natural person or an individual shareholder giving out a loan to his or her company. So from the standpoint of the AIFC law, there are no restrictions on that. However, if your shareholder is a Kazakh citizen, you do need to take into account the prohibition that is contained in the Kazakh legislation, which prohibits natural and any persons from giving out loans unless they are licensed to do so by the relevant competent authority and unless the loan is being granted not by way of business. That's why you see a lot of zero interest loans being given out by natural persons to those.
So-called financial aid, what we usually see.
Exactly.
It is important to mention that if you're an FC participant and you're giving such loan to your company, it must be done through non by way of business. Otherwise, you would be triggering the general prohibition where an FC participant cannot carry out regulated or financial activity without an obtainment of a correspondence license. So the by way of business implies that such entity conducts it as a main business and he holds himself willingly to hold such a business and he solicits other person regularly. So if you do it through non by way of business, that would not trigger the general prohibition. So make sure.
Timirlan, you also mentioned convertible loans. We do get a lot of requests actually from parties that would like to use convertible loans when financing their companies, and we do indeed see that being done in practice. So a convertible loan envisages a lender providing money to a company, and then when certain circumstances arise as prescribed by the relevant agreement, the loan is then converted into equity. So as a means of paying to the lender gets is issued shares in the company to which he or she gave out a loan.
Mm-hmm.
Yeah.
But there is one important moment from tax perspective that I want to mention. From the tax code perspective, there is no such provision like convertible loan, and it actually happens since in the most popular TO form. There is a prohibition to, as I remember, there is prohibition to do so, and the loan from a shareholder cannot be directly, by one transaction, be converted into an equity.
Yes, the civil code has a provision that says that you cannot pay you cannot get shares in exchange for someone forgiving your liability, let's say, if we may use those terms.
And thank you. And actually, that's why the tax code lacks of that principle, and what the taxpayer should consider, and how the tax authorities actually may interpret such transaction, is like two-step process, where first you got a debt forgiveness, which is actually taxable in Kazakhstan, and the amount of, in that case, a loan amount which was forgiven will be considered as income and taxed at 20% corporate income tax. And the second transaction will be considered as an equity injection, which is actually tax-free. So in case if this instrument, I believe it becomes popular, and whenever you hear that, or whenever you consult anyone or just consider to do so, make sure that you consider the tax implications in this case.
Yeah, I think it's always important to assess your tax consequences well in advance. We have set up Astana Stock Exchange. So, like, what if I, as a AIFC registered entity, want to raise financing through that stock exchange? What are the issues that I might encounter?
Yeah, that's right. That would be an alternative to the conventional finance when you want to offer your securities to the public to raise additional funds. In the AIFC, we have regulated trading facilities such as an exchange or an AX in this case, wherein a potential offerer wants to issue, let's say, equity instrument or debt instruments to acquire or to raise additional capital. In the AIFC, we have market rules which regulates the manner, the conditions, the corporate regulations by which an offerer can offer its securities to the public. So the main conditions, one of the main conditions that you must have a prospectus. Prospectus is an essential document which stipulates all the relevant information to the securities. Let's say its assets, its liabilities, what rights attached to such security, and of course, the reason of issuing such security. That's the first part. And the second, there are certain conditions by which you can offer. Let's say you want to offer only to accredited investors, or if you want to target retail, you'll have certain requirements, or I would say restrictions, that such issuance might not exceed $5 million, or you can only target 50 retail persons at once. So that's some basic requirements. And regarding the AX, I would say a couple of words that the high-level listing requirements is that you must have an audited financial statement of at least 1 year for the RAM companies, I would say it's medium enterprises, 2 years for the debt issuance, and 3 years for the equity issuance. Also, there's a requirement for the equity issuance that the public company must have around 25% of free floats. That's the shares in the public hands. Also, the minimum market cap requirements for the debt issuers is the $500,000, and for the equity issuers is it's $1 million. So for the more information, you can contact AX representatives, and they will tell you more about that. Thank you.
Yeah, thank you, Arsen. So let me just summarize key important points out of this discussion. So, like, there are a number of ways to change or to alter the capital of a company registered in AIFC. And in certain ways, AIFC provides more flexibility compared to Kazakh legislation in terms of altering the capital. So like features like optional disapplication of shareholders' preemption rights, as well as absence of requirements to appoint an independent valuer to value or assess the property as part of non-cash considerations are one of the examples of such flexible regime. But at the same time, flexibility causes some complications when it comes to taxation. So like I think one needs to be conscious about those aspects. In terms of raising capital through stock exchange, I guess like the major document that one needs to carefully study is the market rules, which sets up the manner in which securities may be offered and the conditions for admission of securities to trading and official list of the authorized investment exchange. Timirlan, can you just give I know like taxation is something you can talk about like for hours, but like can you just in 5 minutes give a brief overview of the typical like tax issues one encounters when operating as a company in the AIFC? So like I have a business in the AIFC and I want to like understand what tax I need to pay, or like what tax I'm exempt from.
Yes. Thank you, Timirlan. Yes, for sure. Just maybe half of requests we receive are related to taxation in the AIFC, and that's actually because we have this Article 6 in the constitutional law on the AIFC, which grants various tax benefits for our participants. And what I would like to highlight that basically to understand the taxation here in the AIFC, you may kind of separate these benefits into two groups. The first group is related to conducting regulated activities whenever you have a license to provide financial services, or whenever you have a license to provide professional service like accounting, legal consulting, and other services listed. In that case, first of all, you get exemption from corporate income tax. So there's no 20% CAT anymore, but only on income received from provision of such services. So there is one key point that usually, we usually have a calls when AIFC is compared with special economic zones in Kazakhstan. There are many of them. And what actually happens in case of a special economic zone, that you have a threshold which you should not exceed. Like you only have a 10%, or you can only have 10% of income out of your all aggregated income during the year from any other activities except the preferential one. Once you reach the threshold, all your exemptions cease and you have to pay taxes on all 100% of income. And that's actually how it works in certain special economic zones. But in case of AIFC, there is no, like, as far as I remember, there is no direct requirement that you have to maintain certain threshold. You may mix your services with regulated and non-regulated. But in that case, you need to maintain separate, so-called separate tax accounting. Like half of your money should be taxed if they are received from, if that is an income or received from services not provided under the license, and half of your money which are provided under the license are tax-free. Another point, good point, is that you may also receive value-added tax exemption on income, again, received from provision of regulated services. And I should say that this VAT exemption does not actually include provision of professional services. So if you are an ASP, you have, for example, accounting firm providing services to our participants, you unfortunately cannot get an exemption from value-added tax. But there is certain threshold, so you anyway may kind of avoid value-added tax in case if you have a like small to medium entity here. And for regulated companies doing financial business like managing funds, such income will be also exempt from VAT. Another good point is that you may also get a property tax exemption and land tax exemption, but there is one peculiarity that this land and property actually should be located on the territory of AIFC, and I'm not sure if my colleagues already mentioned that. The AIFC territory is, there are borders on the map which actually defines what is the AIFC territory, and just basically speaking, it's the left side of Astana city, Nur Sultan city. Another good point that you may also receive, just it usually happens that whenever we structure business here, our participants say that we want to we want our professionals from foreign team to join the, for example, board of directors, or some get some foreign staff to do operational work here. Can I do so? And actually, will I get any benefits for that? And the answer actually yes, you can. And yes, you will get some benefits. Salary income received by foreign individuals, the citizens of foreign country actually, or people without citizenship, may get an exemption from personal income tax, which is 10% in Kazakhstan, under their employment agreement with the AIFC participant performing regulated activities. And that's, I believe, basically for the first group, those who perform regulated activities. And in case, whenever we have, for example, a holding company here, no license is needed, and that's actually a quite popular request to us. What if I create a holding company here and I just want it to hold the operational assets here in Kazakhstan, Uzbekistan, and other countries? Do I still get any benefits? And the answer, yes, you do. The constitutional law actually has a good provision stating that the dividends paid by AIFC entity to anyone, basically to anyone, there are no like blacklist, there are no special requirements. Such dividends will be exempt from Kazakhstan withholding tax, I would say, first of all. And that is the main difference with respect to how the in general the non-residents income tax in Kazakhstan, since currently, as I understand, the new amendments were signed at the level of parliament, if I'm not mistaken, which actually sees participation, so-called participation exemption, a tax benefit granted to non-resident under the general tax regime, which also may be more beneficial for those who are considering to establish a new entity and just right now choosing whether it should go to Kazakhstan, the general jurisdiction, or maybe the AIFC is a better place. And the second good point is that whenever you would like to exit this jurisdiction by selling of shares, the capital gain income won't be taxed in the Kazakhstan. If I'm not mistaken, the withholding tax rate currently is 15%, and there is again certain amendments that will seize the general tax benefit under the tax code. And another good point, the constitutional law grants this all exemptions that I mentioned before until the 2066. Am I correct, Aisha?
I think you are.
Okay, thank you. And another point that I should mention is that capital gains and dividends exemption, tax exemptions, tax benefits are also granted to any entities, including those performing the regulated activities, professional services, so they are kind of not linked to having a license. So if you are considering to create a holding company, that's actually a good point, I believe, a good point for you. And Tamerlan, I think that's basically it with tax matters.
Okay, thanks. Well, tax issue is always complex and complicated. So, like, we urge to like hire tax advisors before you contemplate to undertake any serious transactions, I guess. Anyway, so like moving on to last cycle of a company. Let's say, like, if I want to sell a share of my company to a third party, what should I take into account of?
Yes, so let's say you are contemplating an exit from a project. Obviously, there are a number of ways for you to do that. And the first method that comes to mind is, of course, liquidating your entity. However, liquidation of AIFC participants is a separate let's say, area of law called insolvency. We have regulations on that topic, and we have rules. It's a very complex, very interesting part of the acting law of the AIFC. However, unfortunately, we will not be able to dive into those during our session as we are limited in time, and that probably ideally will require another session or a series of sessions on those. So today we wanted to focus exclusively on a shareholder selling his shareholding to a third party. And that action will require the existing shareholder to transfer his shares to the third party. And the process of transferring shares is actually not regulated by the Comregs in a very detailed way. So usually the transfer happens, usually it's a four-step process. So the first one is obviously the seller shareholder agreeing with the buyer to transfer shares. That can usually be done by means of concluding a share sale and purchase agreement or a deed of gift or any other contract, depending on the nature of the deal being contemplated. After that, you must complete the so-called instrument of transfer form. We do have that form available. It's a one-page form, very easy to fill in. It's usually appended to the relevant board resolution that you will later on submit to AFSA, that will actually provide for the registration of the new shareholders, but that I will mention a bit later on. After that, the form is submitted to the company by either the buyer or the seller, and the directors of the company, and that's important, they have to decide now whether or not they will register the transfer by means of issuing the buyer a certificate of shares and including the name of the buyer into the register of shareholders. So that's pretty much the process. Now, if you look at the legislation and how the process is regulated, you will see that it's literally half a page of a small section in the Comregs, and it basically states that, well, shares are transferable in accordance with the Articles of Association, and that the directors may refuse transfer of shares only if it is on reasonable grounds. And if they do refuse the registration of that transfer, they must within 14 days provide the transferee with the written reasons why the transfer was actually refused, 14 days after the transfer form was lodged with the company. Now, that leads us to advise you and other potential participants that when you are registering a company and you are drafting the constitutional documents of the company, including articles of association, you may want to thoroughly and in detail prescribe the reasons and situations in which directors may either may refuse to register a transfer or may allow the transfer. And let's say, yeah.
Didn't you previously mention about the preemptive rights?
Yes, actually an important thing to note is that we do not have statutory preemption rights for a transfer of shares. We only have them in relation to allotment of shares. This is different from TORs. In TORs, you actually, before you, as a participant in a TOR, before you transfer your participation or participatory interest into a third party, you have to offer your shares, your interest to the existing participants. With Comregs, it's different. So you may want to include preemption rights on transfer into your articles of association. And then later on, let's say, this will help you not to end up in a situation whereby you have people or companies joining your company that you wouldn't necessarily want to see or to work with. So it's advisable for corporate lawyers to keep that in mind in the very beginning of your business life cycle when drafting the Articles of Association. Another important thing to note is that our regulator, AFSA, It also plays a sort of post-registration role in many processes. Usually it's a requirement to notify the regulator of certain one-off events that happen in relation to your company. That includes change of name, change of CEO, change of director, allotment, and transfer of shares. With transfer of shares, there are a certain number of forms that you need to complete. We have our amazing colleagues from the Participant Support and Sales Department who will guide you through the process. So you complete those forms, you liaise with the AIFC Business Connect, and then you lodge them with AFSA and pay a fee. And then you may consider the process completed.
Thank you a lot, Tesha. I guess it was pretty much helpful. So like just to maybe summarize some of what you've mentioned, basically what you say is that transfer of shares is very lightly regulated. As you said, like it's just half page of in the corporate law, so like one has to pay a lot of attention when drafting their articles of association. So detailed issues of how transfer of shares can be undertaken and what grounds might serve as a condition for like directors to refuse such shares should all be there in the articles of association. So like that's a very important aspect of company incorporation, and one that should not be discarded or like paid little attention to, I guess. So I think we've covered most of the issues that we wanted to. I think we have just some time for questions from the audience. Please feel free to ask if you have any questions. Please. Yeah.
Thank you for this useful overview. Actually, we have a number of questions. Maybe we can start with three, at least. Thank you once again.
Maybe just one, because like it's just like three minutes, and like we'll have to leave the room, unfortunately.
Quickly. On taxation, thanks once again for this overview. But is there any guidance or maybe position paper, or would you plan to have that? Because when you deal with, let's say, Kazakh tax authorities, you would need to, let's say, explain, proof or something. For instance, you explain this permanent establishment regime applicable to recognized companies. But there is a position on that, probably.
Maybe second question related to tax matters. You mentioned that there are some tax preferences, benefits, we know, but as far as we know, these tax benefits they provided from services rendered to the AIFC bodies or participants. So I mean, if we provide services to companies outside of AIFC, then we would not be able to get any tax benefits. So yes, that's an important thing. Yeah, so I mean, just to be on the, I mean, for the sake of clarity, because most of the audience, they can just think that we can provide. So
yes, thank you very much for this clarification. Yes, it should be noted that your professional services should be provided to AIFC participants performing regulated activities, which is financial activities. Otherwise, unfortunately, corporate income tax should be paid. Yes, and with respect to the position of taxation of a recognized company, I may ask my colleagues from tax policy department if we ever issued such a position. But what I should mention that whenever you deal with taxation, the first matter is it's not more about the official position or a letter that you have, because actually it does not have any legal power, maybe in case whenever you have a tax audit and you want to just clarify your position, because even whenever the tax authorities issue their tax letter, unfortunately they may issue one letter confirming that you can do certain transactions, and during the tax audit just say that no, unfortunately you cannot and you should pay taxes. So that's why it's more like from a practical perspective about the assessment of your risks whenever you do a business here. And I hope I answered your questions, but in case if we have an official position, just please contact us. I will try to contact with you and provide this.
Yeah, okay, thank you. That's clear, of course, that that position, even if you had a position paper, that would not have the same, let's say, legal force, but just as helpful to explain certain, let's say, interpretation side of, let's say, this Article 6 of the main law. The second question, if I may, on the recognized companies, also you mentioned that for instance, if a business wants to conduct regulated activities, a recognized company would still be suitable, and would that need go through the same authorization process?
Yes, exactly. For instance, let's say a Kazakh company with the license from National Bank or RFR, they want to expand their business to the AIFC. They'll establish a recognized company, so-called branch, and go through the authorization recognition process, which means they will obtain a financial license from our regulator. So they will be able to conduct a business from within the AIFC, from this branch.
I have one follow-up question, maybe can I ask Aisha? We know that there are several ways to enter to AIFC, way of entry to AIFC, incorporation, redomicile, then registration. And have you had a chance to deal with redomicile of TOO, a limited liability company, registered in Kazakhstan to AIFC? Because that's the question. I mean, we, being a legal counsel, we asked several times. Because based on practice, as far as we know, that it's not so common, or AIFC are not so comfortable with this structure, and it doesn't work well, and it's not well tested as it is. Seems to be. Thank you.
You mean a Kazakh TOO being reorganized into an LTD? Yeah.
Yeah, maybe I'd suggest that you can, like, I guess, discuss this issue like privately, like after the session. Unfortunately, we've run out of time. So those of you join us online, please address your questions to the email that you see on your screen. Let's give a round of applause for our speakers. I hope please free to join us for a discussion outside of the hall. Thank you.
We will be here near the door, so please join us.